Welcome to The Explainer. Today, we're jumping into a legal case from 1987 that might sound a bit dry, corporate finance, right? But trust me, this story completely rewrote the rules on who the law can actually touch, and it redrew the entire map of power as we know it.
So let's start with a puzzle, one that gets right to the heart of this whole thing. Picture a referee who decides the outcome of a championship game. But here's the catch. They weren't hired by the league, they don't have an official rule book, and legally, they have zero authority. So can you challenge their call in court? That was the exact riddle the English legal system had to solve, and it's a question that's more relevant than ever today.
To get our heads around this puzzle, we've got to meet this very strange but incredibly powerful organization. It wasn't a court, and it wasn't a government agency, but in the high-stakes world of London finance, whatever it said, went. So what was this panel? Well, you can pretty much think of it as a private club. It was set up by the big players in the City of London, the banks, the major financial institutions, to basically police themselves. They even wrote their own rulebook to make sure corporate takeovers didn't become a total Wild West.
And this is where it gets really interesting. The panel was a total paradox. On one hand, it had this immense real-world power. We're talking about overseeing deals worth billions with the ability to literally make or break fortunes. But on the other hand, it had no official legal authority from the government. None. On paper, it was just a voluntary body.
Yeah, the best way to think about it is this. Everyone in the financial world just agreed to play by the panel's rules. Not because the law forced them to, but because getting kicked out of that game was simply unthinkable. The panel's power came from collective buy-in, not from an act of parliament.
But a strange, unofficial system like this, it was bound to be tested sooner or later. And a real-world conflict was brewing that was about to challenge the very foundations of the panel's power. All right, so here's the scene. A high-stakes corporate battle. Two companies are in a bidding war to take over a third one, a business called McCorquodle. Now, one of the bidders, a company called Datafin, thought their rival was breaking the rules. So they did what you were supposed to do. They complained to the panel, our unofficial ref. But the panel sided against them, and Datafin, feeling completely wronged, decided to do something nobody saw coming.
That's right, they decided to do the unthinkable. They sued the panel. They challenged its decision in a formal court of law. This was a huge deal, and it immediately slammed into a massive legal brick wall. The panel, by its very nature, seemed to be completely beyond the reach of the courts. See, the crucial point here is that according to the legal rules at the time, the courthouse doors were locked shut for a case like this. You couldn't just sue anyone for anything. There were really strict rules about who the courts could actually supervise. The legal tool for this kind of thing is called judicial review. It's fundamental for holding power accountable. But look at that definition closely. Historically, judicial review only applied to decisions made by a public body, that is, an organization exercising power given to it by law. And this just lays out the problem perfectly. You had this clear line in the sand. On one side, government bodies, which the courts could review. On the other, private companies and social clubs, which they couldn't. And a takeover panel? Well, being a private, voluntary body, it seemed to be firmly on the not subject to review side of that line. It was in a legal no man's land. Now, the first court that heard the case totally agreed, case dismissed. It really looked like the end of the road for Datafin. But then, in a moment of pure legal genius, the Court of Appeal found a key. They found a way to unlock this previously sealed door. This was the breakthrough. Instead of getting bogged down in how the panel was created, its private origins, the judges decided to ask a completely different and way more important question. What kind of power was the panel actually using? This shows the shift perfectly. The whole legal focus moved from the body's private origins to the public job it was actually doing. The old question was all about its source. The new question was all about its function. And this was a total game changer in public law. This powerful quote from the head judge, Sir John Donaldson, just captures that breakthrough moment perfectly. The court realized that if the panel didn't exist, the government would have had to create its own official body to do the exact same job. In effect, the panel was acting as a stand-in for the state. And just like that, a new legal principle was born, the public function test. This test massively expanded the reach of the law. It established that accountability follows power. It doesn't matter if you're officially part of the government. If you're performing a public function, you can be held publicly accountable. So, what did this all mean? Well, ironically, the court actually ended up siding with the panel on the original takeover dispute. So, Datafin still lost its case, but that loss was a historic win for the law itself. Let's look at the incredible impact this decision continues to have today. In 3 clear steps, the entire landscape of public law was redrawn. Suddenly, courts could look behind the curtain of powerful private organizations. The public function test gave people a brand new tool for accountability, and it ensured that massive power, wherever it might be, can be challenged.
So, the crucial takeaway is this simple but really powerful idea. Accountability isn't about your legal status or how you were created. It's about the function you perform in society. If you act like a public body, you can be challenged like one. Period.
And this decision just blew the doors wide open. Now you could challenge all sorts of powerful organizations that shape our lives but aren't officially government. Think about major sporting bodies or industry watchdogs. It even raises a very modern question. What about the giant tech platforms that basically govern our digital public spaces?
The Datafin case gave us an answer back in 1987, creating a tool to challenge the unofficial rulers of its time. And it leaves us with a question that is more relevant and, frankly, more urgent today than ever before. In a world with blurring lines between public and private power, the search for real accountability continues.